Hi, my name is Mike Cosentino. Thank you very much for joining us here on Wiley Resource Center. For the next 25 minutes, we'll be talking to you about legal matters, legislative matters. Joining us tonight is Monica K. Gamble. Later on, we'll have Brandon Nemec, both of whom are from the Illinois State's Attorney's Office. They both represent the legislative unit. And thank you very much for joining us tonight, Monica K.
Thank you. Thank you for having me.
Absolutely, absolutely. So why don't we get started by just telling me a little bit about what you do for the state's attorney and what the legislative unit is.
Well, the legislative unit is made up of three individuals. I have two partners, and basically what we do is, with any entity, we have an agenda in which we try to establish and work with that agenda throughout the legislative session, whether it is proposing new legislation or helping modify any proposed legislation that's going to come up for this year or the following year, and addressing any legislation that might be detrimental to our office. So it's an opportunity for our office to be involved in the legislative process and pass legislation that can help both the state and the citizens of Cook County.
Oh, that's fantastic. Now, before we go any further, I just want to let everybody know that this is a call-in show. The number that you can reach us at is at the bottom of the screen there. It's that 312-738-1060. And a further number, I'm going to throw it up here on the overhead. Wiley Resources number is the 773-738-1480. If you have any questions during the show, if you don't feel like calling in, please feel free to contact Wiley Resource Center with any inquiries that you may have. But if you have questions during the show, please feel free to call us at the number at the bottom of the screen. Now, Monica K., we were talking before the show a little bit about some legislation that your office was passing. Can you tell us a bit about that?
Well, it's not just legislation that we were passing. These are 4 pieces of legislation that we want to discuss today that we thought might be really interesting to some of your viewers about changes to existing law that create opportunities for them. Today we'll talk about 4 different pieces of legislation, and the 2 in which I will discuss. One I refer to as the Sign and Drive bill. It's one of the bills for the Secretary of State's office, and another one that deals with domestic violence. And then my partner Brandon Nemec will be on later to talk about 2 other pieces of legislation, one that deals with kind of a GPS tracking issues, as well as one that deals with juvenile expungements, 2 issues that are also very, very interesting, but also great opportunities for individuals to, for juvenile offenders, as well as those individuals who are concerned about the use of GPS technology.
Well, why don't we start one by one then? You were talking about a sign and drive bill.
Yes, this legislation is really interesting. It's an opportunity now where if you're pulled over and ticketed for certain offenses, you will no longer have to relinquish your driver's license as kind of a guarantee that you will show up in court. It was given up as bail, kind of in lieu of bond in some instances. Here, what we'll do is, with this new piece of legislation, individuals who are stopped, and these do not apply to individuals who might have been pulled over for DUI offenses. Unfortunately, this legislation does not include those type of offenses. But for some of these minor traffic offenses, you will be able to sign your traffic ticket. And that's kind of the option that is available to out-of-state drivers now. If you come in from maybe Ohio or Wisconsin, even Missouri, and if you're pulled over for certain maybe registration issues or some suspension issues, you'll be able to sign your name on the ticket as a guarantee, a promise that you'll show up in court for your court date.
Okay.
Well, now we've extended, not just our office, but the state has extended this opportunity for people to sign the ticket in lieu of giving up your license. You can keep your license, you can still travel, you don't have to worry about renting your car without a license. Maybe you have a vacation planned and you want to board an airline and you only have your driver's license. If you were to go out to dinner, maybe, all those times when you would need your driver's license, you can still have it in your presence and with you at all times.
Right. I mean, that's usually the hiccup that most people run into when they get their license confiscated. What do I do now? Because I rely on that. That's my main source of identification.
Exactly.
And so just to clarify, how does that necessarily differ? Now they take away your license, or currently, as the current state is?
Well, yes. With the current state, what will happen is if you're pulled over and let's say maybe you have a registration issue. They will take the license from you, and then you will have to wait for your ticket to be processed through the court system, which takes a few days. It's not readily available and up in the system.
It's not a quick system.
No, and in some instances, it could take up to 2, maybe 3 weeks before you'll get a court date and you can go in and remedy whatever the issue is. And while you're waiting, you will not have your license throughout that time. So this is an opportunity where that license will stay with you, and you simply sign on the line and you're able to go about your day-to-day affairs without any worry about your identification being removed.
Nice. And like I said, I'm sure that's a great relief to most people, because for most people, that's their only source of identification is the driver's license.
Yes, and with this legislation, let's say you still were to miss your court date for whatever reason. There are some enumerated reasons where you're allowed to prove that the missed court date is not your fault. You will be given 30 additional days continuance from the time of your initial court date. And from that date, they will then move towards maybe a license suspension. It's not an automatic thing. If you miss this initial court date, you're not going to suddenly lose the license that you've been holding on to. There are no immediate suspensions or automatic suspensions as a result.
Well, it's good. Are there any other practical or procedural differences in terms of what the new legislation is going to do? I mean, we've talked about the fact that you're going to remain in possession of your license, and now that you're not going to be docked for, filing late or whatever. Is there anything else that differs, or any other benefits to this new legislation?
Well, the main benefit is you'll just be able to keep your license, and there are some nuanced changes in the procedural aspects of the bill, but none that are really anything that I guess the everyday person would really be that interested in. It's just it's very kind of court specific. It expands, like I said, it does not apply to the DUI drivers, and it won't apply if you have some of the 6303 violations. But in very specific, if you're in a city with a certain new ordinance that may mirror a state violation, it can work there as well. So let's say maybe you're in a smaller town and they have some sort of ticketing offense where you might have lost your license before, you will still be able to keep the license here. So that's another benefit there. And there's another piece of legislation I'd also like to discuss.
Please tell us more.
This one deals with kind of out-of-state issues. So, for instance, if you are a victim of domestic violence, currently, and with the first offense, it is a Class A misdemeanor for the offender. Well, if you've recently moved to Illinois or Chicago, maybe let's say from California or from somewhere out of state, maybe you're moving away from your offender and you're trying to set up a new life here and get established. Well, if they were to come here under the existing law, those out-of-state convictions for that individual would not count when a judge is making a ruling on on this first offense. It'd be considered a first-time offense. With this new law, any offenders who may have a out-of-state background or history, it would be counted as a second and subsequent offense, meaning that it would no longer just be the Class A misdemeanor. Those, if you have a violation of an order of protection out of state, that now can also be included. It really is an expansion of the domestic battery statute that's out there, and it allows for greater protections for those who might be victimized and would not otherwise receive the same protections if it were simply a misdemeanor. Whereas now it will be expanded as a Class 4 felony for a second offense.
So it's sort of like a cumulative type. It's a nationally cumulative type legislation.
Several other states will count out-of-state convictions, but Illinois had not historically made those same distinctions. They just would only count what happened with your criminal history here in Illinois. So this provides broader protections in the state of Illinois for any victims that are Illinois residents or are dealing with someone who might have a background that's outside of Illinois. They no longer have to worry that they have to once be successful in an Illinois court system first in order to be receive some of the benefits of the second, subsequent, or the felony conviction for the offender.
Now, you mentioned, it sounds like initially you were talking about it's targeting domestic violence in particular. Is that so? Is it targeting domestic violence, or is this more of a felony?
Yes,
carryover.
It deals with domestic battery. That is where the change is in the statute. This bill actually comes from downstate, kind of, not downstate, but in the Rockford area, where they had a number of issues. I believe they had, on average, 365 domestic violence-related calls for a service per month. And they saw this expanding. And I believe there was, they had noticed quite a few of the offenders might have had backgrounds in other states, but they were not able to use those backgrounds as they move forward and prosecuted these cases.
Yeah, that makes sense. And obviously, with what's going on the national scale, domestic violence is a big issue,
Yes,
and
yes,
it's a big public issue, and it's something that needs to be addressed. I mean, that's great. What do you foresee being kind of the side effects or the collateral socioeconomic benefits of this legislation? What do you see?
Well, I think
the future of this legislation being?
One of the most significant benefits will be that we have you may or may not know, we have a specialty courthouse at 555 West Harrison. If you have a domestic abuse issue, that's kind of, it's a cumulative center where you can go and meet with someone who will screen the case, talk with you, discuss different options you have, whether it's an order of protection is what you are possibly seeking. As maybe you're moving forward with your criminal case, it will all be centralized in this one location. So now this will let victims know that while they might have these cases, and some people might be returning from other states, and if you're now here in Illinois, you don't have to worry that the offender, your maybe ex-husband or boyfriend or whatever, if you had lived out of state, that he would have to have a history here before you were awarded some of the protections under the law as it currently exists. You would know that prior background would still be counted towards the criminal prosecution and considered as we're moving forward, whether it's at the bond hearing or in the actual case. We will be able to consider that information now without having to wait for the offender to first have an Illinois record.
Well, that sounds excellent. It sounds almost counterintuitive to not have it that way once you realize that this new legislation is being passed. Well, again, we're here with Monica K. Gamble. Coming up, we have Brandon Nemec. They're both representatives from the Illinois State's Attorney's Office. They're in the legislative unit. Brandon is going to be joining us very shortly here. Again, we are a call-in show. The number is there at the bottom of the screen, and I'm going to throw up as well. We're here on behalf of Wiley Resource Center. The number is 773-738-1480. And again, please feel free to contact either phone number if you feel comfortable calling into the show and asking our professionals here any questions that may pertain to your specific issues. If you feel a little more compelled to call in on a more private forum, please feel free to call the phone number that is on your screen right now. Again, that's Wiley Resource Center. Now joining us, we have Brandon Nemec, who is co-workers with Monica K. How you doing, Brandon?
How you doing, Mike?
Good. Thank you very much for joining us. Brandon also has some legislation that he wants to talk to us about. Why don't we first get started with what you do, what you personally do for the state's attorney, and then we can go into a little bit more detail about the legislation that you want to talk about.
Sure. Thank you, Mike. So my name is Brandon Nemec. I am also a legislative liaison. I'm actually a partner with Monica K. Gamble and our third partner who couldn't be here tonight, John Carroll. The three of us make up the legislative unit for the Cook County State's Attorney. We work on behalf of State's Attorney Alvarez to, as Monica said, advance her legislative agenda, and also to track any sort of statewide criminal legislation or anything that affects our civil division or other various divisions in the Cook County State's Attorney's Office. Any laws that would affect our office, we review the legislation, work with our supervisors internally, and then work with the members of the General Assembly in both the House and Senate to advance the legislation or modify it where need be.
Well, that sounds fantastic. I mean, that sounds like a great job.
Yeah.
Sounds very impactful. Why don't you tell us a little about the bits of legislation that you specifically have information on? What's the first one?
Sure. So I also picked out two bills that I thought would have the most impact on the general public, that would be most relevant to the general public to consider. The first one is Senate Bill 2808. That's a bill that was sponsored by Senator Dan Biss and Representative Ann Williams. They're both North Side Chicago Democrats.
Actually, a professor of mine.
Professor Ann Williams at the
Yeah.
John Marshall Law School, my alma mater, where Mike currently attends.
Absolutely.
I heard she's got a great class.
She does. It's
Yeah.
a great time. It's a great time. We talk about legislation all
Yeah.
night on Monday nights.
Yeah, and I'll be stopping into the class the 22nd of September.
Oh,
so we'll
perfect.
see you again, Mike. I didn't realize you were.
Looking forward to it.
Yeah, it'll be great.
Awesome.
We're talking about concealed carry then, so anybody, unfortunately we can't tune in, but
Yeah. Unfortunately, we can't stream it.
yeah.
But
Mike will have some good bits of knowledge to pass along.
I will.
down
I'll
the
pass
road.
it along following Thursday.
Yeah, but this is a piece of legislation that has been sort of a hot topic in the media. It has to do with advancements in technology and privacy rights. There's been a lot of talk at the national level, at the federal level, about what sort of privacy protections that we have as individuals,
Right.
protected not only from law enforcement but from businesses. I was joking with the supervisor about this bill as we were working on it, working to work with the sponsors to pass it through the General Assembly. Back when I was in high school, even, which was not too long ago, I'm proud to say, but
Yeah.
back when I was in high school, I was joking that I could get away with, maybe telling my mom a fib and saying that, I was going over to the church group for the night and actually go out with some friends and do something different, and I could get away with that lie.
Right. Right.
My supervisor, who has children who are in high school age now, he laughs when they try to pull off a quick one like that, because he can take a look at the cell phone records, and he notes that his kid's cell phone that he pays the bill for and has
Right.
access to the records, there is a GPS tracker on that cell phone.
A little different than when we were in high
A
school.
little different than we were in
Just
high
a little
school,
bit.
right? Yeah, a little rough for these kids nowadays. So take note of that. Any of the kids that are watching the show, your parents know where you are at
Right.
all times, as long as you got that cell phone in your pocket.
Right.
That's going to apply to your GPS tracking device in your car. All of these GPS trackers have a signal that's pinging off of a cell phone tower at all times, 24 hours a day, and you can get someone's general location through that cell phone ping tower to know the general whereabouts of where that individual is at any given time, 24/7.
So now, is this anybody can find out where anybody is, or is this you need specific information, or?
So that's what this law pertains to. So as everyone knows, I think from watching enough cop TV shows and Law and Order and shows of that nature, you need a search warrant in order to enter into someone's home, right?
Right.
You see it on the TV show. The police officer knocks on the door, presents a search warrant, and says, the search warrant will say, I have probable cause to enter into your residence or your business
Right.
because a judge has determined that it is more likely than not that you have committed a crime.
Right.
So now I'm going to enter into the residence and I'm going to conduct a search. I'm going to detain you. Your rights are limited in that circumstance because a judge has reviewed the evidence that the police officer and sometimes working in concert with the prosecutor
Right.
to rise to a level of probable cause in order to enter into the residence.
Right.
That also applies to phone records, whether it's a landline phone, whether it's a cellular phone, to obtain text messages, to obtain emails, to obtain phone calls. Because the technology has sort of advanced quicker than the law,
Yeah.
there's nothing on the books right now until this law passed and took effect January 1st of this year. There was nothing on the books that would require the similar court order, if you will, or warrant in order to obtain someone's GPS location. And that's exactly what this bill does. It simply requires that the law enforcement agency and in concert in some cases with the prosecution present enough evidence to convince a judge that there is probable cause that the individual whose location information they are trying to seek, that it is more likely than not that individual is involved in some sort of criminal conduct.
I got you. Now this is I'm gonna sort of take it down to like a layman's version of this, and excuse me, pardon me if it doesn't fall under this bill, but is this almost like the Find My iPhone legislation in terms of oftentimes cell phones being what they are, they're confiscated, and a lot of people don't have access to the information who stole my phone. Is this something that would be helpful with that too, like tracking people that way? Would a normal person under that circumstance maybe not a felony, but something a misdemeanor like a theft. Does this applicable to that too?
So what this would pertain to is a privacy protection. The only limitation here is on a law enforcement agency seeking the cell phone device. So there's actually a specific exception carved out where with the consent of the owner of the cell phone or the owner of the GPS tracking device. Yeah. There's a specific exception if with the consent of the owner, the individual says my cell phone was stolen. Yeah. Go ahead and track it, police officer. Chicago police officer, please track my cell phone and find out where it is. Yeah. The law enforcement agency would be authorized in that case and wouldn't need to obtain a court order in order to track down the phone.
That's excellent, because I know that's been an issue. I know I've had personal experience in that realm, and prior to this, it was last year, that was an issue. We weren't allowed to tap into the cell phone. Sure. Simply because we didn't have control of it, and there was no precedent saying, because I'm the owner of the phone, I have access to know where it's at. Right. They used to say, I can't tell you exactly where it's at because you don't have the phone on you. You have no authority. I don't know that for sure. Right. That's great that this legislation kind of carves out like a little niche for items like this, and I'm sure greater, bigger, more important.
Absolutely, yeah. There's
wrongs being done too.
There's exceptions all the way down the line. Everything from the consent of the owner, as you just discussed, to a 911 caller who's calling from a cell phone who loses a signal or drops the call because they're in some sort of an emergency situation. The law enforcement officer could go right ahead and track that cell phone device and try to seek out that location. The same for any sort of what we call in the law exigent circumstances. Right. Any emergency situation where someone's in peril or there's the threat of imminent harm, there would be no requirement for a warrant or a court order in that circumstance.
It sounds almost commonsensical.
Yeah.
You also said you had a second bit of legislation that you wanted to talk about.
Absolutely. And this one was debated heavily. It's been introduced for years. It's Senate Bill 978. Just passed the General Assembly this past session. The sponsor here is Senator Kwame Raoul, and in the House, Representative Art Turner, both also City of Chicago representatives. This deals with kind of a catchphrase, and it did get a lot of media publicity, juvenile auto expungements. Essentially what this says is if a minor juvenile under the age of 18 is arrested and no charge is ever pursued, what we would refer to as a petition for delinquency, there's no charge pursued, but the individual is arrested. Mm-hmm. And obviously, because there's no charge pursued, there's no conviction. So the state's attorney's office would not pursue a charge in that case. But the individual was arrested, and there is a record of that arrest taking place. Upon turning the age of 18, reaching adulthood, so long as the individual hasn't had any arrest or other incident within the past 6 months, all of the juvenile arrests on their record that did not result in a charge or in a petition for delinquency are cleared from their record.
That's fantastic.
And so what the result that we're trying to achieve here is to give those individuals, who make mistakes when they're minors, but the mistakes aren't, they're never proven guilty of those mistakes in a court of law, not even charged with a crime by the state's attorney's office. In those circumstances, those individuals would be able to enter into adulthood, apply for jobs, and apply for college and apply for post-secondary education without having to disclose the prior juvenile arrests from their high school years or from their younger years.
I mean, do we have an idea of what sort of problem this was prior to this legislation?
I think the real issue it's trying to address is that these types of offenses where there's just an arrest and there's no charge ever pursued, they're already eligible for expungement. Essentially, what this is trying to do is remove the onus on the juvenile, on the person who made the mistake, to have to go to an attorney, to have to seek out legal services to see if they're eligible for an expungement petition, and then to have to go through and apply for an expungement. It's an automatic expungement. It'll be on January 1st of every year after their 18th birthday. Oh, nice. Their arrest records will be reviewed, and any eligible arrest will be expunged from their record. Now, I should say that the eligible offenses, it's only all misdemeanors are eligible, and all Class 4 and Class 3 felonies. any class 2 or higher felony is not going to be eligible for this automatic expungement. The individual would have to apply for an expungement just as they would for any other offense.
Fantastic. It sounds like it's nipping it in the bud. It's nipping the onus in the bud,
Right,
essentially, and taking it off of a juvenile, essentially somebody that's 18 years old.
Right.
Well, again, it looks like our time is about to run out. I really appreciate Monica K. Gamble and Brandon Nemec coming and talking with us today. Again, we are here on behalf of Wiley Resource Center. My name is Mike Cosentino, and I hope you have a great weekend. Thank you for joining us.
Thank you.
Good night.